In January 1936, Delvaille Theard was at the Supreme Court representing multiple clients in a property law case. That summer, everything changed.
In the summer of 1936, I collapsed. There was trouble in my business, there was trouble in my affairs, and I was moved by my family and my friends to a mental institution. It is a fact that I remained there as this patient for more than 10 years.
Eventually, Theard was well enough to return to the law.
And from 48 to 54, during those 6 years that I was permitted to resume practice, and that I actually resumed practice, it is a fact, and that's in the record, that I tried 37 cases in the appellate courts of the state. Real cases, contested cases.
This is where the story is a little difficult for me to follow. The crime and serious illness apparently preceded Theard's first appearance at the court.
In 1935, he had forged the signatures of 2 clients to a note for $20,000, then paraffed it to make it look like a mortgage, and following that, sold it and misappropriated the proceeds. As to that, as petitioner indicated in his opening, he admitted that, but claimed that he was of unsound mind.
Theard's arguments agree with this timeline.
In 1935, I realized myself that my health was impaired. I found it almost impossible to go on. Basing themselves on an act which during my illness I had committed on, as they say, I have no recollection of it, on the 2nd of January 1935.
Theard's insanity defense was sufficient to avoid criminal prosecution, but it was unclear how it should affect his status as a lawyer. 2 years into his comeback, the first investigations began into his earlier conduct.
From 1950 to 1952, there was a series of informal conferences and so on in connection with that investigation.
Theard was disbarred in Louisiana, and the U.S. Supreme Court would not intervene in a state-level issue. But that was likely part of the evidence for the federal courts to also disbar Theard, which was the court's jurisdiction. He decided to challenge his disbarment case pro se in the Supreme Court in 1957. The government's lawyer, Edward Hickey, pointed out that disbarment is not the same as a criminal punishment. There was also a risk that a lawyer who had committed fraud in a poor mental state could offend again.
The Supreme Court of Louisiana, and in turn the District Court, felt that in disbarment, which is not punishment, in disbarment, which is a case of protecting the public and maintaining the integrity of the profession, that the state of mind was irrelevant. The fact was that the conduct occurred, the public was injured, clients had suffered, and therefore the individual involved was unfit to continue to practice the law in those circumstances. There is nothing in this record to show, as a matter of evidentiary fact, that there is a present state that, of mind or a condition that would allow anyone to say that there is no danger of recurrence, there's no danger of relapse, there's no danger that any dereliction would continue in the future.
Theard won the case unanimously, 8-0. The decision reads,
"We do not think that the principles of right and justice require a federal court to enforce disbarment of a man 18 years after he had uttered a forgery when conceitedly he was suffering under an exceedingly abnormal mental condition, some degree of insanity."
I didn't see any information after this appearance at the court, but Theard died 6 years later. He had a challenging decade in the middle of his life, and his comeback story is inspiring. He's the first pro se case that I've covered where he made it to the court twice. None of the justices were on the court long enough to see him twice, but probably they knew. It goes unmentioned because the court works hard to make every case a little more universal. If you want to hear more episodes about people representing themselves at the Supreme Court, please like and subscribe. United States Supreme Court rules and practices have changed since these cases. This was a podcast episode, not legal advice.